Mr. McGee?
Good morning, Your Honors.
Good morning.
If Your Honors, please, I represent Brackett and other officers in connection with this appeal. This case started in 1996 when the MBTA sought from the Personnel Administrator of the Commonwealth permission to have a females-only list and a minorities-only list for promotion to lieutenant, one spot for lieutenant, and 7 sergeants. The Personnel Administrator, pursuant to Rule .10 of his rules and regulations, granted the permission. The only thing that was submitted to the Personnel Administrator in support of that request was a document showing the makeup racially and gender-wise of the MBTA. And that document, which appears at 145 of the record, shows that with regard to minorities, there were a total of 54, and thereby coming in complete, consistent with Castro v. Beecher, which was decided back in 1972.
How do we know that the effects of discrimination as addressed in Castro v. Beecher don't still exist?
Well, I suggest, Your Honor, that Castro versus Beecher has got little, if anything, to do with this case.
How do we know that?
Well, my argument is that it was incumbent upon the MBTA not to just submit to the Personnel Administrator a piece of paper showing the racial and gender background of the department as it existed at the time in 1996. My argument is that, as the rule itself says, before any special certification may be issued, the Personnel Administrator must make a written determination that there was past discrimination in the MBTA for the particular positions involved. Now, the only document that the Personnel Administrator had at this time was this document I referred to at page 145 of the record, and it just shows the racial breakdown. So what the MBTA is saying is that, in effect, the mere fact that there were no blacks in the females in the position of lieutenant, and only 1 or 2 in the ranks of sergeant, that from the mere absence of minorities or females in those positions, one may infer that there was discrimination.
And you dispute that. You don't agree with that.
No, that's fact alone. I mean, there has to be more than that. The mere absence of something.
What other explanation could there be?
Well, as I argue in my brief, to show past discrimination, for instance, it could very well, obviously there was none with regard to the entry level because they were in full compliance with Castro. So now we're talking about sergeants and lieutenants. One of the things they could have done was show, say, or somebody could have shown it, not myself, but that X number of blacks took the exam for sergeant, passed it, and were passed over. That could be evidence of discrimination. This record is silent as to how many blacks took the exam and failed it.
But doesn't Dr. Coopengoods, I think that's the name.
Good, yeah.
Doesn't that kind of settle this whole thing? The doctor found, admittedly an expert, a gross statistical aberration or just deformity in the whole thing. That's never been challenged, so that's the law of the case. You can't dispute his finding or her findings. Doesn't that kind of take care of that whole thing?
Dr. Coopengoods addressed only the issue of females.
Well, at least it's the females. Doesn't it finish anything about them?
Well, my argument is that I say that it's his position was faulty in the sense that all he did was take a survey of the greater Boston metropolitan area and looked into the census figures to find out how many females were in security guards positions, all kinds of so-called police-related activities. And he found out that there was 8.8%. So therefore, he said one would expect to find, when one looks, to find 14.8% of the same minority category or the same gender category in the MBTA Police Department.
So, and the judge accepts that.
But Coppington only talked about that with regard to entry-level positions. As a matter of fact, the judge said in this decision, because the number of positions we're talking about was so small, that you couldn't come up with any valid basis, a valid formula. But the mere fact that Coppington is addressing the entry-level positions, that may very well be true, but he was not addressing the issue of sergeants and lieutenants.
But you can only attempt to become an officer after you have entered at the entry level, correct?
That's right.
So if you're not given access at the entry level, you can't become an officer at the higher level, correct?
Correct. But as of October of 1996, there was full compliance with Castro versus Beecher.
At the entry level?
At the entry level. Now, there are other rules requiring eligibility to take the exam. You have to be a patrolman so much time before you can become a sergeant, etc. Let me just point out what happened here, Judge. We had Brackett, for instance, first on the list. And he was bypassed by a woman who was seventh on the list. Using the normal procedures, she was not eligible to be promoted because under the Civil Service's Personnel Administrator's own rules, for one vacancy you can take from the first three. For two vacancies you can take from the first five, three from the first seven. So under the own rules, she was not eligible. So what they did was, we'll ask for a female-only list. So she went from seventh on the integrated list to second on the female-only list.
But doesn't that ignore the history of women not having had the opportunity to get in at the entry level? Don't you have to factor that in too?
Well, this is the crux of the whole matter. But what about these people who took the exam? And anybody who knows anything about police work knows that you spend at least a year studying for this thing.
What about the women who never got to take the exam because they couldn't get in at the entry level for years and years and years?
Well, I understand what you're saying, but does that automatically say that my client's people have to stand aside for this?
No, it doesn't automatically say it, but it goes to the question of whether or not one can redress past discrimination. In other words, the question is who's standing aside. It's a difficult and a complex one, but it seems to me that unless you were introducing evidence that showed at that moment that there was no lingering effect of past discrimination, it's something that courts have routinely looked at. I mean, by your ruling, by your interpretation, you would say that when it comes to civil service or civil service-related positions, you can never depart from the top of the list, or you have to. If there's one position open, you can take the top three. If there are two, the top six.
If you want to please, nowhere in this record is there any suggestion or proof, rather, that there was past discrimination against women. Castro versus Beecher did not involve women. What they're saying here is the mere absence of women at the sergeant's level and the lieutenant's level, R4CR, there had to have been discrimination. But there's never been a judicial determination or an administrative determination that there was discrimination against women in the MBTA for purpose of promotion to sergeant or lieutenant. And so, therefore, we
But I thought you just said a bit ago, Dr. Kuppengut or whoever it is, your criticism was that analysis was about the entry level. That seems to me that does then put this back in the same posture as Castro versus Beecher. You have evidence of discrimination at the entry level, which is going to have rather obvious ramifications as you move up the ladder, and that accelerating minorities and women up that ladder is necessary as part of the remedy of the past discrimination against them at the entry level.
Dr.
This is what the judges have said, that these statistics are strong enough and good enough to indicate past discrimination that will be remedied by this particular approach?
Dr. Coppengood merely stated that he would expect to find, based upon his survey of Greater Boston metropolitan area, and then it was supplemented by, later on, they gave him figures for the whole state. And I objected to that because I had a hard time believing that a person in South Hadley, for instance, is going to be looking for a job in the MBTA police department. Historically, most of these people apply for these jobs, apply for the community or a surrounding community where they live. But Coppengood said, I would expect to have found that. But I said to him, is there any evidence here that you can see, calling upon your expertise about discrimination here? He says, I was not asked to address that question. So all I'm doing is telling you today, I expected to find that, and I didn't find it.
Mr. McGee, what are the qualifications for entry-level positions?
High school graduate.
So
the rest of it, veterans' preference is another matter altogether. But high school graduate primarily is what the qualifications are, and then taking an examination and passing it.
Physical exam also.
Oh, I'm sorry, the physical. It goes without saying the physical.
Do you have to be a Boston resident?
Pardon?
Do you have to be a Boston?
Some, for the T, no.
Can we take judicial notice that there have been a lot of female high school graduates over the years?
Well, that's an interesting question. I think I'm sure there have been, but taking judicial notice of it, perhaps you can.
Well, it strikes me that Dr. Coppengood, at least in his second analysis, when he was able to access all of the data statewide, was not really looking at the number of women in the labor force generally, but was really looking at women who were qualified for law enforcement duty. In other words, qualified applicants, looking at the qualified applicants versus the number who actually had entered the service. Isn't that a reasonable way of looking at this?
I think what he did was take women in the protective services field, which he included in their security guards and other jobs. The issue here to me is on the minorities. There's only one piece of paper in this record from which anybody could say, well, from those figures, we're going to infer that there was discrimination. And that's the document on page 145. Put that, and Judge Kottmeyer, in support of her position that there was, in favor of the MBTA, said that this document plus, and then she reverted to Castro versus Beecher, which is 24 years old, in which the T was in full compliance. So here these people took the exam, and I think what happened here, and my argument is that when the results came back, and it was realized that these promotions couldn't be made under the regular rules, because under 2N+1, the commissioner could, the MBTA could have said, we can take 1 out of the first 3, 2 out of the first 5, 3 out of the first 7. But the females didn't even meet that qualification. They were 9, 11, and 16. A person who was on 16th place jumped over 6 officers. 16th place. Now, what does that do for the integrity of the competitive civil service system?
What it does, as Justice Sussman suggests, is to say to remedy for past discrimination, you can accelerate up the ladder. In other words, the very notion of acceleration is that because of past discrimination, you have to set aside what is otherwise an even-handed application of the civil service law.
Well, I argue at least, that's a very harsh rule. I mean, a person who, take the lieutenant's exam, spend over a year studying for that examination, time away from family, time giving up paid details, giving up overtime, because it's so highly competitive. And after it's all over and done, and you finish first, all of a sudden you're told that somebody who finished 7th on that list is now going ahead of you. That's harsh. To that person, that person is a victim.
Mr. McGee, of course it's harsh, just as it is harsh when somebody applies for a job, has the high school qualification, has the physical capacities, and is told, we don't hire you, or we're not going to hire you, with no explanation given. And it turns out that it's because of gender or race. That's harsh.
Your Honor, nowhere in this record is there any evidence of how many females even applied for this job between 1986 and 1996. We don't know how many applied. We don't know how many took the exam for the T and passed it.
Well, wait a second. Is there a separate examination for MBTA police? I thought they just took the police officer exam.
It's a statewide examination.
Yeah, and
some 23,000 people took it, I think, last year.
Yeah, and according to this, 14.8% of those people who took and passed the exam were females, which is where the number comes from compared to what the MBTA's acceptance rate is.
But then once you get that passing score, then it's up to you to make it known to the T or the City of Boston or South Hadley or whatever that you'd like to have a job with their department. It's not the T's job to go out and go down the list of all 18,000, 19,000 that passed and say, would you like to come to work for us? So we don't know how many females who passed the exam actually contacted the T and said, we'd like to have a job with you. Second, the same logic applies with regard to sergeant. All I'm saying here, I see the red lights going on. To me, I'm arguing that it's a very, very, well, first of all, with regard to the minority part of it, there's no way that one can just say that based upon one piece of paper, and Coppergood didn't address it, one piece of paper, the absence of minorities in these jobs, a fortiori compels the conclusion that there was, in fact, discrimination. That just can't stand. With regard to the female list, the same arguments I just got through making, that we don't know whether there was any, there's never been any determination of discrimination by any court in the T with regard to females. Never.
Thank you, Mr. McGee. Mr. Quinnen?
May it please the Court, I am Robert Quinnen on behalf of the State Human Resources Division. The affirmative action measures approved by the Human Resources Division in this case easily pass constitutional muster on account of, A, principally, the record evidence of discrimination, secondarily, adjudications of discriminatory behavior by the MBTA in other cases, and thirdly, the compelling need for more female and minority leaders within the MBTA police force.
Well, let's look at what Mr. McGee just said. The MBTA, presumably, didn't produce any information concerning the number of women who actually applied to be police officers with the MBTA. Isn't that the basis, the population from which we should then extrapolate as to how many should have, if statistics were a proper gauge, how many should in fact be on the police force?
Well, the MBTA did produce statistics for a 10-year period from 1986 to 1996 of the number of women who sat for the promotional examination. We also had data regarding the number of hires.
For the promotional examination?
That's right.
Okay, well, Dr. Kuppengood is just dealing with the entry level.
There was data for entry level as well. And more to the point, we knew exactly how many women had been hired by the MBTA.
Now, I understand you knew how many women had been hired. That's obvious. But did you know how many had applied? Obviously, the MBTA should know how many have applied.
I take it your point is they're looking at the women who are hired and then watching their rising through the ranks and saying there's a disproportionate impact.
We're looking at the disproportionately few number of women who were hired by the MBTA over that 10-year period.
How can you say if it's disproportionate if you don't know how many applied?
Because we know how they can apply, which is by passing the promotional exam. We know what percentage of women pass the promotional exam.
14.8%, yeah.
That's
now
right.
Dr. Kuppengood has that pass the statewide promotional exam to be a police officer. Mr. McGee says if you want to apply to the MBTA, yeah, you have to do that. Then you have to apply. So isn't that the population we should be looking at? How many of those who applied were accepted, and then statistically, does that seem to suggest something other than it seems to suggest discrimination?
Well, the First Circuit has said that it's not necessary to look at strictly the number of women who have applied having passed the examination, because that may not uncover the discriminatory hurdle in the entire application system. If there is something that precludes women from even applying, then there could be discrimination that needs to be remedied through a carefully calibrated program such as this.
Well,
what evidence is there that something precludes women from applying?
Well, one of the most significant factors perhaps in this situation is the fact that there was this absolute preference for veterans, and as the U.S. Supreme Court found in the Feeney case, that had a very severe impact on the opportunities for women to join police forces in Massachusetts, because the number of women who could enter the military was capped for a long period of time, and as a result, no more than 2% of women were military veterans. And if there's an absolute preference for hiring women, they're not going to get in the front door.
But is that discrimination? Or, I mean, that sounds to me like the veterans, I mean, the legislature has made a judgment that veterans should get preference. How's that the MBTA's fault?
It's not the MBTA's fault, but it's nevertheless discrimination against women. It is
based on the legislature, so the veterans' preference law is discriminatory, obviously, is what you're saying.
There are discriminatory effects from the veterans' preference statute, which the MBTA is entitled to take into account in devising an affirmative action plan. Another important statistic in this case is that the percentage of women on the MBTA police force was dropping rather dramatically as a percentage of the force. And we know that in 1988, the percentage of women on the force was 11%. In 1994, it had dropped to 9%, and by 1996, it had dropped to 7%.
And was that investigated, I assume, maybe by the Attorney General's office or about...
It was investigated by the Attorney General's office, and the Attorney General concluded that there was rampant discrimination at the MBTA at that point in
against
time.
Women?
Against women and minorities.
And how was that memorialized?
The end result of that was a very far-reaching equal employment opportunity agreement by which the Attorney General could take unprecedented steps to ensure that, that all of the vestiges of discrimination were swept away.
So what you're saying, is, I think in essence, is that when we look at the statistical evidence, Dr. Coppenwood with regard to women and what the MBTA supplied with reference to race and women, the case is virtually overwhelming, or to use the language of the Richmond decision, substantial basis in the evidence, or whatever language they use, to show that this disparity still exists many years after the Castro decision, which then triggers the Rule 10 certifications and ultimately the action that was done here.
Yes.
It all hinges on this statistical stuff.
That's right. The U.S. Supreme Court in 3 different cases has held that there is no doubt that where there are gross statistical disparities can be shown, they alone, in a proper case, can constitute prima facie.
That's the key. They alone, the word
That's
alone.
right.
So if this statistical stuff holds up to analysis, then that's probably the end of the ball game.
It's the end of the ball game when it comes to the compelling state interest. It's clear that there is evidence of discrimination.
Yeah. Could I ask you, though, as I understand it, this evidence of past discrimination is supposed to be put forward at the time someone seeks HRD's approval. And it seems to me that as this case developed, it sort of ultimately came out, statistics about women and whatnot. But none of this was presented at the time that the approval was sought.
I don't think that's accurate, Your Honor. First of all, 2 years before, the MBTA had submitted its affirmative action plan to the HRD, which contained detailed information regarding the representation of women and minorities on its workforce. They then submitted statistics from May of 1996, And finally, before asking for the special, or at the time they asked for the special certification list, they submitted updated statistics in September of 1996. So all of that data was before the personnel administrator at the time he approved the issuance of the special certification list. The remedial method employed under Rule 10 was narrowly tailored, and if my time is up, I will leave that argument to my brother counsel.
Thank you, Mr. Quinnan. Mr. Hitt?
May it please the Court, Robert Morris representing the MBTA.
Oh, I'm sorry. Mr. Morris.
Yes, yes. Following up on what Mr. Quinnan was just talking about, the part of the analysis is whether the remedy was narrowly tailored.
Would you agree with him and me that if the statistical stuff holds up to analysis, that's pretty much the end of the ball game on the fact that there is discrimination and therefore there's a compelling state interest to correct this?
Yes, I would agree that we have.
So now we're down to your piece, which is the remedy.
The remedy, the so-called narrow tailoring. Judge Kottmeyer, in the opinion below, one of the opinions in below, went through various factors.
Well, first of all, there's no property interest held by the plaintiffs in these promotions.
That's correct. There's case law from this court to that effect. Only qualified applicants were preferred. If you look at the actual numbers of the scores, 4 of the appellants to this matter had scores, for the sergeant positions, had scores of 80, while 2 of the one of the minorities and 2 of the white females had scores of 79. So you're talking a small gradation.
Well, the issue is not a question of small gradation. The question is, can you select from, notwithstanding the existing civil service or the MBTA's internal policy that you have to take, if there's one position open, somebody that's in the top 3, whether or not you can take from more broadly from the pool of admittedly qualified persons, correct?
Yes, and the personnel.
In other words, there's no claim here that these women and minorities are not qualified, correct?
Not directly, but I did want to address that point on the narrow tailoring piece. There's no evidence here of any other. This is not an ongoing program, if you will, that every year that minorities and women would be preferred. This record shows a one-time use of Personnel Administration Rule 10 to promote women and minorities. And you also have to look, and this was a point made in the Commonwealth's brief, that if you had not, if this hadn't been done here, if you had gone on the strict rank ordering, you would have had a situation where you would have had 21 sergeants, and you would have had just one female.
Has anyone suggested any other way of doing this?
In terms
making it, quote, more narrowly tailored than what was done here?
I don't believe so, Your Honor.
Well, isn't that part of the answer? No one says you can do, here's a better way to do it?
That's true, Your Honor.
Would you complete your thought there would be 21 sergeants?
Yes, because there was 7, and there would be one female. There would have been one female sergeant, 1 out of 21, and one minority sergeant, 1 out of 21, if these selective certifications had not been utilized. I also wanted to mention, and this was mentioned by Mr. Quinnan, but this EEO agreement that was entered into between the MBTA and the Commonwealth in February 1997, which is just a few months after these promotions took place. Now, there is a non-admission of liability clause in there, and I'm not moving away from that, but the historical fact is reflected in this record, is that there was a 14-month investigation of allegations of racial and sexual discrimination and harassment at the MBTA, and the agreement actually operated like a consent decree, though it wasn't technically a consent decree, but if the Attorney General had concluded that it was not being properly adhered to, they could have gone to court to seek injunctive relief in regard to the compliance, and that is not taking away from Castro v. Beecher, but that's not 1972 that we're talking about. This is contemporaneous with the action taken by the MBTA.
And what did the Attorney General's investigation reveal with respect to discriminating against women applicants for the MBTA police force?
It did not get to that level of specificity.
Okay.
Your Honor.
I thought I just heard Mr. Quinlan say that the Attorney General had reason to believe, it concluded that there was massive discrimination on the basis of both gender and race.
Yes, that is the Attorney General's conclusion for the whole MBTA system, and it was an agreement not only with the authority, but 26 of the 27 labor unions at the authority signed off on that agreement as well. So, and I did want to mention that the record shows that of the 7 appellants, 5 of them were subsequently promoted to sergeant. Oh, there's only 1 lieutenant here, 1 lieutenant position, and 5 sergeant positions. That is undisputed, and in the record, there's only 2 have not been promoted, but 5 of the 7 were subsequently.
Yeah, but that won't do anything for you. You've got 2 plaintiffs here who are still, as the others, it may be moot in some sense, but at least as to 2, they got a grievance that we need to,
All right.
you know.
But at least to the vast majority, they did secure a promotion.
Can I ask you whether the EEO agreement or the agreement you entered into with the Attorney General was submitted to HRD as part of the basis for your asking for separate female and minority lists?
Well, it was not submitted to HRD. It wasn't entered into until a few months after the fact. It was.
But there's a lot of stuff that's going on after the fact here.
Well, this proceeding has been elongated. It's taken 10 years to reach this level. We had 2 remands to the Civil Service Commission, and we were entitled to introduce evidence.
So that's not in the record. This agreement with the Attorney General.
It's very much in the record. It's very much in the record.
So it was submitted at some point.
Yes, to the Civil Service Commission.
To the Civil Service Commission.
Mr. Morris, let me ask you this. Is there some reason why this was there was only a one-time use of this administrative, use of Rule 10?
I don't have that. It's not in this record, and I don't have. And honestly, I don't have that information.
Is there anything in the record that shows how often do these promotions to sergeant and lieutenant take place?
I don't know that it's in the record. It's it's not. It's periodic. I don't think it's on a set schedule at the T police force. We're not talking an enormous police force, obviously, from at least on the promotional level. But
it doesn't happen according to any set schedule. I mean, they don't do it twice a year, 3 times a year. It depends on certain circumstances that we're not totally familiar with when they decide to fill some of these vacancies. Am I right?
Right.
Well, we have in the record, at least you say that 5 of the 7 people have been promoted. Do we have anything in the record that shows whether women and minorities have been promoted as well?
I don't believe so, Your Honor. I don't believe that is in the record.
Thank you, Mr. Wallace.
Thank you very much.